Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We're recording this on Friday, August 2nd, 2024. In this week's episode, we'll be discussing an officer accused of failing to intervene in the Uvalde school shooting pleads not guilty in the wake of the mass tragedy that left 19 children dead. Plus, a man convicted for the Apple River stabbing of several teens begs the court for compassion and appears to receive it. But first, a woman charged with murdering her husband faces a major obstacle as two key motions are denied by a judge ahead of closing arguments, and we will find out soon enough if that had any effect at all on the results. Today, we are joined by Mark Bederow, a former prosecutor and current criminal defense attorney. Mark is also a legal analyst you can catch on multiple media outlets, and you should. I always enjoy hearing Mark's comments on these cases. Mark, welcome.
Thank you. Glad to be here.
Absolutely. And I meant that. I really do appreciate hearing your thoughts, not just because you're a practicing criminal defense attorney and a former prosecutor and have years of experience doing this, but I always feel that you bring a sense of balance and thoughtfulness to all of these cases. And I know that you've been following these cases closely. So let's jump right in. First, out of Brockton, Massachusetts, a Massachusetts woman accused of fatally stabbing her Boston firefighter husband has been found guilty of second-degree murder. Christine Ricci, not to be confused with the actress Christina Ricci, faced one count of murder for the death of her husband, Gulf War vet and fireman Michael Ricci. At the time of the deadly incident, Christine claims that Michael was in the throes of a manic episode and became violent, causing her to brandish a kitchen knife in an attempt to scare the man. Prosecutors, meanwhile, claimed that Christine's mental health had been deteriorating since the discovery of her husband's affair and stabbed Mr. Ricci in the heart and back in a heated argument. Before closing arguments were underway, the defense suffered two major setbacks when the judge denied a motion for jurors to consider a self-defense argument and a request to include medical records suggesting Mr. Ricci had bipolar disorder. Despite this hurdle, Christine's defense insisted that the prosecution had not met their burden and could not prove that the woman intended to kill her husband, while the state was steadfast in the position that jealousy and rage provoked the wife's fatal attack. After 3 hours of deliberation, however, and just moments before we sat down for this recording, the jury came back with a verdict of guilty on second-degree murder. Her sentencing hearing is scheduled for August 22nd, and Ricci faces up to life in prison. Mark, we've seen, it seems like a rash of cases lately where it involves spouses, especially women, it seems like, taking the lives of their husband or estranged husband based upon, a couple of things. One, they're kind of arguing abuse in the home, but it really comes down to this self-defense argument. And we saw with Ashley Benefield, she was convicted of manslaughter, not murder. But now we have Christine Ricci convicted of murder. Is there anything about these cases that, obviously they're factually different, but is there anything that stood out to you that was a difference maker, you think, in Christine Ricci's case?
Well, I think certainly in the Benefield case, she had a lot of evidence of spousal abuse in which she was the victim, in which she felt was directly relevant to, ultimately what happened in that case. And I guess you could say she got partial credit, not that that makes her side feel any better, but she was not convicted of murder. In the Ricci case, there was a lot of, evidence by the prosecution suggesting more jealousy-related anger over an affair. And the noticeable difference is that she didn't testify, which even though they weren't allowed to literally get a jury instruction on self-defense, it's kind of surprising that she would not have testified to what was happening in that situation, which ultimately resulted in her husband getting stabbed in the heart and shoulder, wherever it was. It's very rare, I think, that we would have clients testify. You'd prefer it never happened, but there are certain situations where it almost has to. And this would seem to be one of those if you're looking to have the jury understand the abuse angle and what's going on in her mind. And you have to, in some sense, explain the conduct. I mean, the evidence is that her husband, who's a much larger man, is dead on the floor with fatal stab wounds. And they offered nothing, in essence, to confront that other than legal argument or factual argument by the lawyer that wasn't supported by any evidence. So it's kind of not surprising in that sense that they came back, convicted her of murder in 3 hours, which is pretty fast for something like that.
Yeah. Yeah, I agree with you. I was really kind of surprised by the decision not to put her on the stand, especially in light of that ruling that they wouldn't be allowed to argue self-defense. I'm hoping that you could walk listeners through that a little bit. Why was the judges have what we call a sua sponte duty to instruct on certain things if that is developed through the case. Why does a judge have the ability to say, I'm not going to allow you to argue a certain defense that you feel like is your best defense?
Well, I mean, in order to instruct the jury specifically on any particular defense, there has to be evidence that will support it. And one can imagine that the offer of proof that was made by the defense that would support a justification, just legal term for self-defense, that there was not enough evidence. Now, that could relate to what the proffered testimony would have been from the defendant, such as I was just hanging around with a knife and he came at me and I got scared. I mean, in order to support a charge, there has to be a reasonable view of the evidence that a reasonable jury could find that what is being said could be possible. And, you know, there are times where that threshold is not met. Certainly, in a case like this, the only way you could even get the instruction is if the defendant were to offer the testimony. So if the defense was never even going to testify, on what basis could they even get this evidence in? Now, I'm not sure if the decision for the defendant not to testify came after or before, but if they had made an offer of proof that she was going to testify, that he came at me, I got scared, I picked up a knife, he wouldn't get away from me, he's abused me for years, this and that presumably there would be the instruction. It may not be a compelling defense, but that I would think would be enough to at least get it to a jury. It's you know, in many ways, when you're claiming spousal abuse and you don't get the charge, then it leads me to believe that the proffer that's being made to support the charge is lacking. There's no reason for the judge not to allow it if there's some degree of evidence that could support it.
Yeah. Yeah. Excellent way of explaining that. And for people watching and listening too, I mean, it makes sense. You know, you can't ask a judge to give an alibi defense when there's no evidence of that. You can't ask them to give an instruction on eyewitness identification of the defendant when that's not really in dispute. They have to make sure that they tailor the instructions to match the facts of the case. And in this case, the judge did not feel there was enough evidence to support an argument even for self-defense, so that you can't have the defendant, or pardon me, the defense attorney just standing up there and kind of making up a defense out of whole cloth without there being testimony to have supported that.
So the other thing that was kind of surprising in the summation, apparently, which I did not see, but which I read about, the argument was that she was self-harming or was going to self-harm with a knife, and he came in and he got accidentally injured and, you know, stabbed in the heart and back, which I'm not sure how that would happen in that scenario. But, you know, for a lawyer to make that argument without a shred of evidence to support it, again, the evidence would have come from if she testified about what I was doing, which she didn't. That to me is a surprising decision that she not testify. If that's your defense, I don't know how you expect anything other than the result you got here and the time you got it, unless she, you know, it's one of those rare situations where she takes the stand, tells the jury, and perhaps they believe her, perhaps they sympathize with her, who knows? But for the lawyer simply to argue that that's what happened in a purely speculative context without a shred of evidence, that's a tough strategy from, you know, the way I view it.
No, I agree with you. And not to place all the blame at the feet of her attorney. One of the things that lies solely in the discretion of the defendant is whether or not to testify. So I imagine, or I have to imagine, that they had this conversation and that they realized they were not going to be able to get a self-defense instruction if she did not testify. I think we all agree if she testified and she said he came at me and I defended myself with a knife, they're going to get that instruction. But she must have known, or they must have had a discussion that they're not going to be able to argue that unless she testifies, and she made the decision for whatever reason, her background, cross-examination, her ability, her comfort on being on the stand, all of that. It was her decision whether or not to take the stand. And I agree with you. It really hamstrung their defense. One last question I had about this that I kind of find interesting. I'm curious about your thoughts. Comparing this a little bit to the Benefield case, but just on the simplest of terms. In Benefield, the weapon used was a gun. And here we have a knife. And to me, a knife is far more personal. You're within arm's reach by definition of the person to harm them. But it also seems more improvisational, more lending itself towards someone just grabbing whatever's handy to defend themselves. So it was even more curious to me that she didn't take the stand. But how do you think that just the idea of the weapon involved may play a role in these self-defense cases?
I think you're right. I mean, I think a knife is definitely something that's much more up close and can be something that's lying around. There are many different types of knives. I mean, you see kitchen knives, something happens in the kitchen. You, as you said, you improvise, you grab something, as opposed to a gun, which clearly, if a gun comes out, the likelihood of what's going to happen if it's used is almost certain. So I think, yeah, would have supported Ricci perhaps testifying more, assuming there was any kind of explanation about what the knife was doing there, who had it first. The only problem that she might have is, you've got one right in the heart and one in the back of the shoulder, which are two distinct actions. I mean, in theory, one of those actions could be justified and the other isn't, depending on the circumstances. But yeah, no, I don't understand. I think the circumstances almost called for her to testify. I think the knife would have helped. And I also think that, it's the kind of thing where you would make the offer of proof to the judge before the trial starts. I mean, you would know what the evidence you're offering is, kind of the judge would say, if that's what it is, then that would support a charge. You would know what you're going to be cross-examined with. Every state has disclosures that have to be made to a testifying defendant. So, you would think that those issues would have been fleshed out before trial, so they kind of don't get caught with their pants down at trial and have to improvise and end up in a situation where there's a summation about an issue over self-harm with no evidence to support it. I mean, unfortunately, I'm sure the lawyer had to know at that point that this was a Hail Mary chance at that point.
Yeah. Well, as much as we can discuss this, the jury has already made their decision, like I said, and we're going to be hearing about what sentence she is facing later in August. Let's move to Hudson, Wisconsin, where a man who stabbed several teens, while tubing has been sentenced to decades behind bars, but some are speculating that the sentence is a little lenient. Nikolai Mew was convicted of first-degree homicide back in April for the attack that left teen Isaac Schumann dead and additional teens injured. Mew will serve 20 years behind bars on the murder count and then be subject to 5 years of extended supervision for 4 counts of reckless endangerment and 1 count of battery. While prosecutors sought a 70-year prison term for Mew in order to protect the public, a judge saw it differently. In his determination, he noted that the incident perpetrated by Mew was in poor judgment, but that the man didn't need criminal rehabilitation and didn't possess a criminal history. Mew spoke to the court in a tearful address, apologizing to the family of Schumann and begging for compassion from the court. Meanwhile, his victims and their families gave impact statements illustrating how Mew's poor judgment had dramatically changed their lives. Mark, first of all, just jump right in. This case took place a while ago, but I'm curious on just your thoughts in general. A lot of people were very heavily divided on this one. How did you come out about what degree of culpability this man had?
Well, I don't think this is another self-defense in a legal sense. I mean, self-defense, your actions have to be reasonable under the circumstances. You have to perceive an imminent threat of deadly force before you yourself use deadly force. And something obviously happened between these two groups, but ultimately he had a knife and used it, killed someone, stabbed other people, and sounds like he just went crazy or was paranoid, perceived what was going on in a way that maybe reality wasn't. So in a legal sense, would I think his actions were justified just because people were yelling at him because they thought he was doing something weird? No, I don't think anybody would say that that permits you to pull out a knife and just start stabbing and slashing anyone within your immediate arm span. So on the other hand, I understand what the judge is saying in that this was obviously not a premeditated act. It's not something that anybody planned. The guy had no record, not a young guy. You know, he seemed otherwise like a good citizen who just used terrible judgment. So I can understand why the sentence would, to some, appear low. I don't think 20 years is low at all for a lot of people. I mean, 2 decades in state prison for somebody who's never been arrested can be a long time. But the prosecution asking for 70, that seems a little much. But I don't have a problem with him being convicted on those facts, and I don't necessarily have a problem with the sentence. You know, he did kill someone without a legal basis to do so, and he severely injured other people in the process. I mean, you know, very serious consequences for very serious acts.
Yeah. Many people who have been critical of his conviction talk about, well, the man was being attacked. And that is true. I think he definitely was justified in defending himself. Now, what does that mean? How far was he allowed to defend himself? What would be a reasonable response to how he's being attacked is really the question. I don't think anyone would be having the same conversation if he had just merely punched a few people or threatened a few people with the knife but didn't actually use it. But you are only allowed to defend yourself as is reasonable under the circumstances and as much as is reasonable to stop the threat. Whereas, and I think where you, Mark, are coming out on this, and I tend to agree with you, is this was just overkill for the threat that was upon him by that knife. We're not, to call it a stabbing, I don't think is an accurate description. He killed one man, but then if you saw the injuries to one of the survivors, I mean, he nearly opened this person up. So we're not just talking about kind of wielding a knife, maybe a couple of puncture wounds to people that, accidentally, unfortunately kill somebody. He was using this knife in about as deadly a way as you possibly can. And so, yes, I feel bad for the man. I feel like he was being attacked. I feel like he did to a certain extent have justification to defend himself, but this was just too much.
Yeah, I mean, every state, their self-defense laws address proportionality, which is what you're talking about, and also a very big distinction between repelling ordinary physical force and using deadly physical force. And it's all wrapped up with the proportionality point. But if somebody, like you said, comes at you and you perceive a physical threat, yeah, you can defend yourself. But if somebody tries to poke you and push you, you can't shoot them. That's disproportional. And this is just another form of that. I mean, even if he reasonably perceived that he was about to be attacked with ordinary force, punched or whatnot, that the law, no state is going to allow someone to pull out a knife and, like you said, just start slashing and gashing anyone who comes at you in that point. That's not reasonable. It's not proportional. And even for a guy who doesn't appear to be a criminal, other than this act, there are going to be serious consequences. And, I think the judge factored that in, all of that. I think 20 years under the circumstances seems actually pretty reasonable.
Yeah. Yeah. It's, these self-defense cases, I think people get caught up a little bit. And we saw that with Benefield and with Ricci, that they get caught up in the idea of, was the person being attacked, as if that's the end of the question. And it really isn't. It's, you can both be suffering from domestic abuse at home. You can both be in fear. You can both be under attack and still have committed murder or committed a crime, depending on how reasonable you are in your response to that. So all very fascinating and interesting cases. And 20 years. Yeah. I mean, tremendous amount of time for a man of his age and with no criminal record, especially.
Yeah, it's almost a life sentence. I don't know that it would be, but that's a serious, when you factor in the actuaries of who he is and how old he is. I mean, that's tantamount to almost a life sentence.
Absolutely. Well, moving on now to our final case out of Uvalde, Texas, where a former police officer has pleaded not guilty to charges after allegedly failing to act in the tragic Uvalde school shooting that took the lives of 19 children and 2 teachers. Adrian Gonzalez faced a courtroom filled with the bereaved family members of the victims as one of only 2 law enforcement officers indicted in relation to the shooting. While over 400 officers responded to the incident, authorities allegedly waited more than 70 minutes to confront the assailant. Though the community has urged prosecutors to hold more officers accountable, to date only Gonzalez and Uvalde School Police Chief Pete Arredondo have been indicted, with both men pleading not guilty to the charges. Gonzalez was allegedly one of the first to respond and has been accused of not following his training and abandoning the children who fell victim in the attack. Mark, we're starting to see this more. And I think it's a response to culturally our frustration with these school shootings, that we just seem to be at a loss at what to do and how to stop them. And we saw this. I want to talk about, a case that happened a year or so ago with Scott Peterson, was the Parkland school deputy who was put on trial for his alleged inaction in that case as well. Now, he was found not guilty, went all the way to trial. Where do we stand here? Where is this all going in your view when we are holding these first responders responsible in a situation like this? Criminally responsible, by the way.
This is not going to be a popular opinion. I don't think these are well thought out or intelligent prosecutions. Even recognizing how angry people are at these officers, and rightfully so, how unqualified they were for their positions, how they failed children who died that day, failed everyone else to follow through with their duties. But when you start using child endangerment statutes, which are essentially designed for bad parenting and not taking care of people who you have a direct responsibility over. I mean, literally a parent child or custodian child, that sort of specific relationship, to use that in a broad sense over what is perceived to be a police officer who is incompetent and just fails to follow through with their duty in a criminal sense. I think the danger is there you are opening doors and creating slippery slopes about inviting prosecutions of people for, as you said, school shootings are primarily the ones, and it's not even just first responders. You saw this in those cases in Michigan, the parents, about whether they should have known about, and I didn't really like that criminal prosecution either, although that was a little more, again, that was a parent child with direct warning signs, not just judging the competence of police officers. I think this is inviting too much. There are actions that should be taken. These officers should be terminated. Obviously, they're not qualified. The districts in which they worked certainly are going to be subject to all kinds of liability for negligent hiring, negligent practices, that sort of thing. But I think when you start sending a message to every first responder and police officer that you are going to literally be criminally judged by every action that you take, to every fast moving job that you respond to, that I don't think that's a good use of the criminal law, and certainly not if you look at the statutes that are being used. I mean, these are literally designed for people who don't take care of their children and things like that.
Yeah. No, I agree with you. There's no easy answers on this, but I am troubled by it as well. And what you talked about is opening doors and slippery slopes. And no one, you and I both, no one is saying that we agree or condone the behavior of some of these officers. I mean,
No,
if
awful
they're
conduct. Yeah.
correct, but the question is it criminal conduct? And because in the criminal world, we are used to dealing with bright lines. It's the idea of this is acceptable and this is not. And if you do something that's not acceptable, you're going to go behind bars. And where is that needs to be clearly defined so people know what to do and what not to do in order to avoid breaking the law. In a situation like this, we're starting to really confuse that line, and that line is becoming far less clearly defined. For instance, in this case, one of the things we pointed out is 400 officers responded to that. They've charged 2.
Right.
Why not 400?
Right.
Why not 200? Why are those other people not criminally responsible? And you could say, well, they weren't in charge. Well, if a law is being broken, isn't it your duty to ignore orders that are illegal and go ahead and take it upon yourself to follow? I mean, it's just when you start to flesh this out and ask these questions, it becomes more and more troubling.
It does. And I think also, I mean, think of this, the impact on police officers who you want to, I mean, they're different than us. They most of them, not these guys we're talking about now, but they run into trouble. They get shot at. Some of them don't come home from terrible things that happen at work. But do you want police officers who are involved in making very important decisions, which could save people and put themselves in jeopardy, thinking, am I going to get arrested if I do this or not do this? I mean, it's for so many different reasons. This is just, to me, that this prosecution in Texas, as awful as it is, I mean, 19 children, it's terrible. And, you have to be concerned in the sense that if that case proceeds to trial, these are not going to be popular men. I mean, they failed. I think we all agree.
Yeah.
They're not the best of what the police are, but, serving them up as sacrificial lambs because we're all outraged at school shootings, I think is just a very short-sighted view on, as you noted, and I'm talking about now, what happens going forward.
Yeah. And we don't know. I mean, there may be facts and evidence that we're not aware of that make this criminal. I'm not saying that they can never be held criminally responsible. There may be something that comes out where, everybody was telling them it's safe to go in. And if we go in now, we can save lives. And we have a plan of attack and execution and everything else. And this officer still could have said, stand down. And maybe that does reach the point of criminal. I'm not saying it's never an opportunity for criminal prosecution. I'm just saying that, to your point, officers are going to be watching this case very closely moving forward. And it may affect how they respond and how they act. And it may not be to the way that we're hoping. It may not be that we have officers who are more willing to, rush into a firefight to save lives, but they may be more concerned about their own criminal responsibility and just protecting their own behavior and not behaving in the right. We don't want officers worried about all of these kind of criminal ramifications when they're trying to save lives. So again, it's not there's no easy answers. It's just a case that makes me wring my hands.
Yeah, no, I think that's a tough case and just not a great idea by the Texas authorities. But
yeah,
I mean, everyone's pissed. I get it. But criminally I don't think, the way to go.
Yeah. Well, again, I'm going to keep an open mind because, let's say that there is more to it, and maybe we're wrong, and maybe there is some actual evidence that these men need to face criminal charges, and we'll see how that plays out in court. But it's too broad of a discussion for us here in one episode today. So in the meantime, that is our show. And Mark, I wanted to thank you so much for coming on this week. Where can people find out more about you?
I use a Twitter page, Bederow Law, BEDEROWLAW. That's the best place.
Fantastic. And check it out. And again, if you get an opportunity to watch Mark talk about some of these cases, as you've heard already today, you will not be disappointed. In the meantime, I am your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you are curious to hear more of my thoughts and coverage on even more true crime cases, you can check out my brand new YouTube channel, Courtroom Confidential. And of course, you can find all of our Sidebar episodes wherever you get your podcasts, and we want to hear from you. If you've got questions or comments you'd like us to address, tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.